Now back to the show. This is AM 650's The Law Show.
Nice to have you with us this Sunday morning. Red Robinson and The Diner coming up at noon. Our guests on this episode of The Law Show are from Murphy Batista, LLP. Joe Murphy is one of the founding partners. Mr. Murphy is a QC lawyer, and he is joined in studio by Angela Price-Stevens. Angela spends a lot of time on medical malpractice files. We learned a fair bit, disappointing lesson, I'm afraid. Not your fault either, you two, but an important and very valuable bit of airtime to learn about the Family Compensation Act as it is in British Columbia. It's been this way for decades. It's a terrible bit of legislation. Attempts have been made by umpteen lobby groups over the years to get all sorts of different political persuasions of governments to change things. Nothing has happened. It's seriously overdue. Joe, I wanted to talk to you about causation, because you mentioned it would be a good thing to talk about on the radio, and I thought, well, sounds provocative and interesting. What is causation?
Causation, Sterling, is the connection between someone who does something wrong, like a motorist who's not paying attention, and the harm that's caused to a person who's injured. So if I have a person stopped at a red light and they're rear-ended and their neck is injured, that's pretty straightforward.
Right.
But if I get the person stopped at the red light who's got an arthritic neck and is having active treatment for that arthritic neck, and the injuries worsen, then the question becomes, what's the motorist or their insurance company responsible for? If I get someone who's got a history of falling and they've got weak bones and they trip somewhere and fall and have terrible fractures, then is it the person whose place was unsafe and the trip was caused, or was it the weakened bones, or was it the history of prior falls? Who's responsible for what?
Okay.
So in some cases or instances, causation is really straightforward. It's so obvious. But in other cases, it's difficult and complicated, and the courts have tried to provide sort of a roadmap as to how to find out who's responsible for what.
Does it complicate things at all for lawyers and this whole causation thing that we British Columbians are very well tuned to a no-fault mindset? Nothing is anybody's fault, especially in traffic law. And, it's okay, it doesn't matter who caused what. It's no fault. Everybody pays the same insurance. And it's misleading when we think of a no-fault environment because, of course, there are causes and people do cause harm to others, Joe.
Well, it is, and we have a no-fault system in British Columbia. It's called WorkSafe. It used to be called WCB.
Right.
And if you talk to people who are injured on the job and who make claims for their losses, my experience is 9 out of 10 of them are very unhappy with the system and how they were treated. If you talk to the employers, they may say, gee, we're happy with the system because it keeps our premiums down.
Sure.
So it really depends on whose side you look at or look through to decide how good this system is. But workers dealing with WorkSafe are, in my experience, invariably unhappy with that. It's simply not fair. And it's one size fits all, and that doesn't work out
right
fairly to anybody.
Angela, in personal injury or medical malpractice cases, is causation or fault? It's the nub of the case, isn't it? Somebody wronged somebody else, and that's what it's all about.
Well, causation is often the weak link in the majority of medical malpractice claims. And what I mean by that is you can have a client come to you, tell you their story, and it's quite clear when you listen to them, you look at the records, you look a little deeper, that there was clearly a breach in standard of care. Somebody did something or failed to do something that they ought to have done, and there you have that first tick. The first box is ticked. But what you then have to look at is, what did that specific breach cause? can you link that breach to the outcome? And one really simple example is I had a client once who hurt her ankle, and it turned out this was actually quite a significant and serious injury. She went to her family doctor. The family doctor barely looked at her ankle and said, "Oh, you've just sprained it, don't worry." That was it. End of consultation. And my client thought, no, this is really painful.
Right.
So she went to her pharmacy. She bought an air cast. She took anti-inflammatories. She iced it. She elevated it. She actually did all of the things her doctor ought to have told her to do.
Right.
She ended up, it was quite a serious injury. But the fact is, we couldn't, or I could not, pin the doctor for a medical malpractice case because in fact, there was no causation. The client herself had stepped in, and so she had broken that chain.
Oh, I see. And thus sort of short-circuited her own case in that.
Well, absolutely. And good for her, because she would have had a much worse outcome.
Right.
But, all the things that he should have told her, she went and did herself. And so she ended up with the same outcome that she would have had she had good advice in the first place. But causation is, that's a very, very simple example. Usually in a med mal case, it's way more complicated than that. And as I say, that's usually the weak link, and so that's where defense normally focus their attention.
Joe, can I use an example that you cited a moment or so ago? You were talking about an older, frail person who has some kind of osteoporosis type, weak bones condition, fairly commonplace, who suffers a fall in a public environment after tripping over something. Now, that if this person comes to you and they're a little messed up from the fall, but they've had falls before, you're going to go to court representing that person, and the cause, as you see it, would be the article on the floor that caused the person to trip and therefore fall. I would assume the opposition is going to say this person is of a certain age, has experienced falls before. This is a pattern that we just unfortunately saw occur again on such and such a day. There is no cause. Is that the root of that case?
That's part of it. The other explanation is to say, well, these injuries would have occurred anyways. It was invariable that as her bones got weaker and weaker, this would happen.
Right.
Angela mentioned a case a few minutes ago, and I did a case years ago involving a little boy who was born following a long delay in the delivery, and the evidence was clear that this baby was in distress and should have been delivered earlier, and
Right.
the evidence showed that there was 20 or 30 minutes between when he should have been delivered and when he was.
Okay.
This little boy tragically had a variety of ongoing disabilities, which, from my point of view, I thought were linked directly to the delayed delivery.
Sure.
But when I consulted an expert and said, can you say that these difficulties are probably as a result of the delayed delivery, the expert said, no, I can't say that. So that meant that case didn't proceed because I couldn't prove that the negligence in the delayed delivery, and I thought that was going to be fairly easy to prove.
Well, it seems cut and dry, doesn't it?
Was the cause. So you need that link. You need to say this negligent act caused these damages. And in that case, I didn't have the link because my expert said, I can't say that. I can't say it may have been that this little boy was going to have these same problems anyways, because some children who are born and delivered at the proper time
still experience
have
those
these
problems.
kinds of problems.
Sure, right.
So that was a case where I thought it was obvious when I first started out, but when I looked at the need for an expert to say there is a link here, I couldn't get that, and the case was abandoned.
Interesting, Angela, nodding quite vigorously throughout Joe's talking about experts, because you also rely on the testimony of experts to advance your cases in court. How tough is it to get an expert to come in and participate in a trial like that?
Well, fortunately, I have, I'm placed in a fantastic firm, and I've been practicing now in Vancouver 7-8 years. I have a good reputation. So for me personally, I have a very broad range of experts that I can go to, and I have some real key go-to people, whether they're the right expert or not, they can specialism or not, they can put me in touch with somebody else.
If it's not their file, they can tell you someone
absolutely.
Who's, right, okay.
So
your network is pretty solid.
I work hard on my network. I have to say, you cannot do this work unless you have a good, solid network. It's not just names that you need. You need to know their reputation, how many times they've given evidence. Do they have a reputation of changing their mind? Are they easy? I need somebody who's solid.
Well, I was just going to say, because isn't there a kind of a cynicism about some of these experts? These people are essentially professional witnesses who make their living by testifying at trial. Or is that perhaps something we've all picked up on from watching too much American TV?
Well, I think in certain areas of personal injury, that's the case. I mean, there are certain defendant insurers that will go to the same person over and over and over, and I could dictate their report for them when I haven't even met the client. So certainly there is an element of that. But in my line of work, it is of no value to my client or me for me to go to a plaintiff's hack or somebody who, who's got a reputation for always telling a plaintiff counsel what they want to hear. I don't want that.
Right. Professional witnesses aren't necessarily the best witnesses.
Absolutely.
Okay.
My ideal expert is somebody who works or has taken instructions and provided reports for the CMPA as well as from the plaintiff's side, because that way I know that if they give a good opinion, good supportive opinion, the CMPA are going to more likely listen to them. The
CMPA being the lawyers that represent Canada's doctors.
That's right.
And they're a tough bunch.
They are a tough bunch, yes.
Okay, so experts have their place, but maybe, again, too much TV late nights, we place too much emphasis on their testimony and their impact.
Well, actually, in fairness, I don't think you can undersell the role of an expert. That was not my point. You cannot do these cases without experts.
Sure. And Joe just to give us a good example of that.
Absolutely. But as I say, it's not TV. It's not sensational. It's actually a hard graft and paying attention to detail. And picking a good expert who's got the right background, the right experience, the right expertise.
Right, indeed. We'll take a quick break here and we'll come back with more with our guest from Murphy Battista LLP on The Law Show here on AM 650.
This is AM 650's The Law Show. There's more of the show still ahead.